Hello, this is Matt on the Moon Family Sedan channel. I recently published a video in which I was questioning effectively, is our XRP actually safe? In terms of when you're talking about the SEC v. Ripple case, what conclusion is Judge Torres ultimately going to come to, not specifically just with Ripple, but as it pertains to secondary market transactions for XRP? And it's an open question. And I think we're safe with our XRP. I'm not 100% confident. I don't know, and I acknowledge we could get a disastrous ruling from Judge Torres. But I lean on the side of, I think for so many reasons, which I've been fleshing out over a very long period of time, I think we're going to be safe with our XRP ultimately on that front. And just to kind of drive the point home further, I'm going to share with you some of the latest stuff from Attorney John Deaton, literally from just earlier this afternoon. And it prompted Attorney Jeremy Hogan, after he read through what I'm about to share with you from John Deaton, Attorney Jeremy Hogan retweeted it and wrote the following. This Deaton thread should be put in the Crypto Twitter Hall of Fame. Read on for why sales of an asset sold as a security do not maintain that status in the secondary market. And I will tell you, after going through this, I certainly felt that much more confident that we're going to be okay as it pertains to that specific item regarding the future of our XRP, the status in the United States here, certainly, which will have global implications. And once we get this ruling, even if you're not in the United States, it's still going to be global in terms of price action. But before going further, I do want to be clear. I do not have a legal or financial background of any kind. I am not offering legal or financial advice. And you definitely should not buy or sell anything because of anything I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. All right, so what kicked this off? Well, there was a conversation, and for the purposes of this video, I'm not literally going to go through the whole thing that prompted Deaton to say what he said, but there was this thread, including conversation from XRP community member Mr. Huber, as well as former SEC attorney Mark Fagel, who was sharing some of his perspective. And although I frequently don't agree or find the arguments from Attorney Fagel particularly compelling, sometimes I do actually, I think he's operating in good faith, so I'm happy to highlight what he's doing here. Seems like a pretty okay dude. But he was asked this question by an XRP community member named Matt, and Matt wrote, "Here's the part I just can't seem to resolve, Mark. If I, or anyone else, purchases XRP on an exchange/secondary market, with what entity or entities have I entered into an investment contract with? If the answer to that question isn't clear, that would seem to be an issue." And former SEC attorney Fagel responded and wrote, "That question assumes the secondary market transactions require a Howey analysis. This is by no means clear. It could be that if the seller has issued securities to the public, then the instruments being traded remain securities. I think it's an open legal question." And so there you go. That's the part that should be alarming to XRP holders, because it depends on how this is going to be ruled upon by Judge Torres. And again, optimistic for the future. But again, he's writing here, this is the key sentence. He said it could also be that if the seller has issued securities to the public, then the instruments being traded remain securities. Yes, so a couple of things on that before I even go further. And then we'll get right into the stuff from Deaton from this afternoon. But yes, there's a list of things that can be considered securities. Okay, I've shared that. It's a big list, actually. Digital assets and cryptocurrencies not part of that list. So there are certain things like stocks, for example, securities, just by definition. But if you're, so that's a different question than is something an investment contract? Because if you're looking at is something an investment contract, it's never the underlying asset which would be part of the investment contract scheme effectively. It's never the underlying asset in those situations that would actually be the security here. But what if we do get some sort of weird ruling here, where this thing that's issued, in this case XRP, what if it is actually viewed as that? Because again, I don't think it's going to happen, but we could get some wacky ruling. Well, here's why, even if we got that, it took going all the way to the Supreme Court, I don't think that such an argument would be able to live forever. I really don't. And this is some of the strongest stuff on this point from Attorney Deaton I've ever seen. So here's what Deaton said just this afternoon. So he retweeted what I just shared with you from Attorney Fagel, and Attorney Deaton wrote, I understand Mark's comment that secondary sales are an open legal question and whether a Howey analysis must be applied to secondary market transactions. But when you look at the existing case law in totality, it strongly favors that you must apply Howey at each subsequent sale. If an investment contract remained one in perpetuity, it would nullify the common enterprise factor moving forward. And so he puts together this hypothetical, and this is just fascinating, and I think this highlights the degree to which it would be absurd for XRP to like always be considered an actual security, or for it to mean that we're just forever in like some sort of weird, funky common enterprise together. So check out this hypothetical from Attorney Deaton. Ripple sells XRP to Johnny Crypto's business, who pays his employees in XRP. His employees have never heard of Ripple and use XRP on their debit card. The employee owes his friend $500, but instead he gets the friend to accept 1,000 XRP. The friend has the $1,000. He wrote 1,000 XRP and then he wrote $1,000 XRP. So I'm assuming he just meant 1,000 XRP. But because then that would be equivalent based on the current market rate, obviously. It would be more or less equivalent to the dollar value. But anyway, so the friend has the 1,000 XRP sent to his Uphold XRP address. That friend hires attorney Jeremy Hogan to write up a contract and asks Jeremy if Jeremy will accept XRP as payment, which Jeremy does. Jeremy adds the XRP to his already large bag. I like that. XRP suddenly rockets to $10. And Jeremy surprises Tenvu on a trip to Florence, Italy. And of course, I'm assuming most of you are aware Tenvu is Attorney Hogan's wife. And then Attorney Deaton says, it's Friday and the banks are closed, so Jeremy contacts TapJets and pays for a private flight paying with his XRP. And so I'll pause note there. TapJets is actually a firm, just as a reminder, that filed an amicus brief in the SEC v. Ripple case, and they solved with XRP and other cryptocurrencies what they call in the industry the Friday night problem. Because when you're talking about private flights on private jets, which you can charter, if you're talking about chartering in the continental U.S., they noted that a flight may be $60,000. If you're talking about something, we're heading overseas or something, could be like $300,000. Well, if the banks are closed, you got a problem there, because these things need to be paid for up front because they're so damn expensive. So it's called the Friday night problem. If somebody just wants to go, I know, rich people problems, right? But if you do want to go, it's an actual problem. And so, business being business, they realize, hey, wait a minute, XRP is a thing that has an actual value. You can facilitate transactions literally any time, like 24/7, 365. So TapJets was like, hey, this has nothing to do with profiting from XRP. We have no association with Ripple. And I'd cover the whole thing. It's such an interesting amicus brief. But you see what he's saying here. So it goes from one person, as he said here in this hypothetical, somebody's getting, paying employers are getting paid in XRP, and then he pays a friend he owes $1,000 or $500 to, gives him 1,000 XRP instead. So there's the next step, and then you're talking about hiring attorney Jeremy Hogan to write up a contract, and then ultimately, he says again here, it's Friday night and the banks are closed, so Jeremy contacts TapJets and pays for a private flight, paying with his XRP. And so look at how many times it's changing hands. You see what he's getting at here in this hypothetical, right? It's changing hands many times for many different purposes, having nothing to do with Ripple whatsoever, right? And then Attorney Deaton says, if you don't apply Howey at the time of each transaction, and XRP is a security per se, because Ripple sold to a guy named Johnny Crypto, then, in effect, Johnny Crypto, his employee, the employee's friend, Jeremy Hogan, Uphold, and TapJets are all in a common enterprise with Ripple. The fact that people acquired XRP as a payment becomes irrelevant. It becomes irrelevant if TapJets immediately sold the XRP for fiat to pay their employees and costs, thus clearly not acquiring it for investment or relying on the efforts of anyone. What about the Foreman case? The Second Circuit said, quote, when a purchaser is motivated by desire to use or consume the item purchased, to occupy the land or to develop it themselves, as the Howey court put it, the securities laws do not apply, End quote. And so, folks, this is what I'm getting at here. If you think about the absurdity of this, how many times it's changing hands for so many different purposes, and we're all in the common enterprise, and so therefore these transactions are illegal, that's just silly. And then when you look at case precedent here, as he cited here from the Second Circuit, no, if you're using, consuming the item, purchase, whatever, so on and so forth, as I just cited, it's on your screen right there. Well, securities laws do not apply. Duh. And then Attorney Deaton says, do oranges become securities sold by grocers? Because think about it. So if you talk about the SEC v. W.J. Howie Co. case back in 1946, the court did find that there were illegal securities transactions, and the Howie test came out of that, right? But once the oranges from those orange groves, which are part of that scheme, once those end up in grocery stores, those transactions, those grocery stores selling those oranges, those grocers don't become part of that scheme then. That's not a securities transaction. It's a freaking orange, you little idiot. You know what I mean? It's like you stupid people at the SEC. And that's the thing, they know this. They're just being terrible people. Anyway, Attorney Deaton continues. Spend the Bits uses XRP to spend Bitcoin. You can spend $100,000 in Bitcoin buying a car using the Spend the Bits app, and it will cost you 0.00005 XRP to do it. According to the SEC, the $100,000 in Bitcoin is not a security, but the 0.00005 XRP, fraction of a penny, are securities. And he's got a facepalm emoji for obvious and good reason. And then Deaton says, Spend the Bits offers an alternative to Ripple's on-demand liquidity, although much smaller scale, yet it is in a common enterprise with Ripple, according to the SEC. So think about this, and I'll just mention this in Spend the Bits amicus brief in the SEC v. Ripple case, because they filed one as well. They noted that in theory, if what they're doing scales, that Spend the Bits could become a competitor to Ripple and Ripple's ODL products specifically, utilizing XRP as a bridge currency. So think about this. You're talking about two companies in this case. If it were to evolve to that point, where you'd have Spend the Bits and Ripple, actual competitors, in a common enterprise together? What? The competing forces, competing businesses are in a common enterprise together? In what world does that make sense? That is the stupidest damn stuff. And then Attorney Deaton says, we all should be able to recognize the absurdity. This is why I got involved in library on behalf of Naomi Brockwell. We have the Howie case. We have Joyner. We have the Foreman case. And consumptive intent equals no securities laws apply. Yeah, and I'll also pause note one more thing. This is the reason I believe that Ripple stopped with their programmatic sales of XRP back in 2019, and they've only since then, for years now, sold XRP for the purposes of on-demand liquidity. It's a legal maneuver. I think it seems very obvious. They haven't stated that publicly, but come on. It's pretty obvious. And then Attorney Deaton says, we have Telegram making clear that the gram itself is only alphanumeric code and was not the security. The Hinman speech says the token itself is not the security. Clayton's letter to Senator Ted Budd, North Carolina, agreed the token itself is not the security. In the Ripple case, the SEC says, quote, stripped down, XRP is just computer code, end quote, and denied making the argument that XRP is per se a security, which in effect is what they argue. Yes, I'll pause and note there also. If you ask the SEC attorneys, those little asshat prick attorneys, are you arguing that XRP per se, by the nature of it existing, is a security? They will say no. The stripped down computer code, right? But then if you look at their actual arguments, they start talking out the other side of their mouth, and the arguments are such that if you follow the argument, they are arguing that XRP itself is a security. Very clearly. Then Attorney Deaton says the Aquasonic case, judge said how he was to be applied at the time of the transaction. Attorney Lewis Cohen did an exhaustive study on federal appellate case law and found no case to support the underlying asset being the security. In my amicus brief, I challenged the SEC to cite one single case that found an investment contract when there existed zero privity or communication between a buyer and a seller/promoter. The SEC couldn't do it. So when you take all the law into consideration, the SEC has nothing to support its theory that secondary market sales are also securities. Some may argue that the SEC has a right to pursue novel theories, unsupported by the law. I disagree. The SEC has the authority provided by Congress and existing law. And if they push novel, unsupported theories, then say hello, fair notice defense. Spot on. So that's an excellent thread, obviously. And so, just as an XRP holder myself, and I'm sure that you guys are as well, because this is an XRP-centric, crypto-focused YouTube channel. Right? I have been doing this ever since I jumped into crypto in late 2017, so over half a decade now. I've been doing my best to stay as informed as possible in what's going on in the XRP ecosystem. And also, ever since the lawsuit happened, making sure that from a legal perspective, I'm as informed as possible and doing my best to understand what's going on here, given the fact that I'm not, and most of you listening are not attorneys. And it's very complex. So we have to find trustworthy sources who are willing to share their perspectives. And I'd love to see opposing viewpoints so that I can just, as a non-expert, see who I believe is making the better argument. And so when I go through all this, and because I've been talking about this in recent days, I've made other videos where I'm bringing up this point. Are we in trouble? Is there a possibility that XRP is going to have a major price hit if we get some sort of terrible ruling from Judge Torres having to do with secondary market transactions? Well, I don't know about you folks. I want to be informed, though. Even if the news were bad, I'd want to be informed. But from what I'm seeing here, even though nothing is guaranteed and we actually still could get bad news, I think we're going to be safe with our XRP as it pertains specifically to secondary market transactions. That's a huge deal. I care about that more than whether or not Ripple has to pay a fine. Whether or not Ripple technically wins, I'm interested in it, I care about it. But really more so in terms of what the impact would be for the XRP ecosystem. But what I'm much, much, much more interested in, and I think it's much more crucial that everybody else that's an XRP holder, if you're not Ripple, it's what's XRP's life going to look like in the United States once it's all said and done. Because if we get actual disastrous rulings, and if they were upheld, my God, I mean, we're talking about financial ruin for a ton of people. And so, to me, that's something that needs to be taken very seriously by everybody that holds XRP, and also crypto, though. Because, I think that the SEC, if they get a win on this front, they're just going to continue to go after everything. They'll feel that much more empowered, emboldened. If something becomes precedent, then, well, there you go. That's bad, too. And again, I'm not saying that to scare people. I'm just acknowledging the reality of we don't know for sure, but I don't think that's where this is heading. I think that our XRP is ultimately going to be safe. I think we're going to get the types of rulings that we want here. Now, former SEC attorney Mark Fagel responded to that threat from attorney Deaton, and he wrote the following. As I said, yours is the countervailing view, one I view as wholly reasonable, and I don't know which position will ultimately prevail in court. But your argument seems to rely on the assumption that the token is a consumable, i.e. crypto equals oranges. But what about the vast majority of tokens that are simply magic beans, that have zero use, which investors are trading because they assume one day some greater fool will purchase them at a higher price? These are akin to classic pyramid schemes, and it seems illogical putting form over substance. So, I gotta pause right there already. If he literally means that, and he said it's akin to a classic pyramid scheme, I don't think he knows what a pyramid scheme is then. Because for a pyramid the scheme to exist, you're talking about there's a promoter of something who recruits people to sell and recruit to more people, who then sell stuff and recruit to more people, and then more people, and then it branches out in such a way that you could draw a triangle around it. That's what that is. That is not what's happening in the vast majority of these cases where there's development of crypto. So consider this. A couple decades ago, right, during the dot-com boom and bust, there were tons of dot-com stocks with business models that were horrible ideas. So also there are tons of cryptos and developers that are working to develop use cases that are horrible ideas. So the fact that people bought both of those things, both the dot-com stocks a couple decades ago and some of these stupid-ass cryptos that don't do anything with the hope that maybe they're going to be something in the future. The fact that people bought both, hoping that they'd be able to sell it for more money to someone else in the future, does not make either a pyramid scheme, as attorney Fagel suggests. That's not what a pyramid scheme is. Because when you're buying something, you're always hoping that at some point, you're hoping that along the way, as you hold it, it would become worth more over time, and that if you want to, you will be able to sell it to somebody else in the future. That's the point. That's the point of investing. So if people are doing that with crypto or dot-com stocks, It's the same thing. So unless there's an actual system where people are recruiting people to recruit people to recruit people to sell this stuff, then it's literally not a pyramid scheme. So to say that it's akin to a classic pyramid scheme, so maybe he's hedging his bets there by writing that it's akin to it. No, it's not even akin to it. It's nothing like it unless you find an actual example where that's what the method is. Otherwise, it's not akin to it even. Attorney Deaton responds to Attorney Fagel and says, "We probably agree more than we disagree when we delve into it. Had the SEC actually pursued pump and dumps, fraud cases, scam meme coins, etc., I probably would suffer from far less confirmation bias that the SEC is an utterly broken agency. Brad Garlinghouse commented that 99% of the tokens are useless and will go to zero. I think he underestimated because that would leave 200 plus tokens. As for speculation, according to Howie, it's immaterial whether the asset is used for speculation or has no intrinsic value. People should be protected from the scammers, no doubt. But today, they need protection from non-elected bureaucrats pursuing a political agenda. But yes, we need Congress to act." Yeah, and so obviously I think we'd all, if the SEC were just going after the fraud cases, the actual scams, all that, we'd be praising the SEC, we'd be applauding them. Yes, go after that crap. But if people are working in good faith to build out an ecosystem where a digital asset can solve problems in the real world, the nature of that does not equal a pyramid scheme, and it's not akin to a pyramid scheme. It's neither of those things. It's a bad argument from Attorney Fagel. Now, look, I still think he's operating in good faith. I just think that's a very weak sauce argument from him. I don't think it makes a damn bit of sense here. And I think that people, if you're an adult, how about some personal responsibility? I get it. If somebody's getting scammed, they're getting scammed, then you blame the scammers. Fine. Of course, we'd agree on that. But if something just doesn't work out and it turns out to be a bad investment, we're all adults here. Isn't that you're going to blame people that were trying to develop something if they're operating in good faith? Like, come on. So I'm with Attorney Deaton on this. And again, it's as he cited here, it's speculation doesn't make something some sort of illegal security. That's not how this works. Even if there's no intrinsic value in an asset, that doesn't make it a security. That was determined in 1946. Take it for what it's worth, but I'm just saying, like, after logically thinking through this and having Attorney Deaton help all of us to understand his perspective and just flesh out the concept, I don't know about you folks, but that's why I was saying that even at the outset of the video and throughout the video, I think we're going to be fine with our XRP. Because even if we get a bad ruling from Judge Torres, she'd be wrong, right? And again, I'm not an attorney, but I'm listening to opposing viewpoints, and who has the more compelling argument here? Attorney Deaton. And this is how we have to operate in life in general. You could say, well, that's risky. You're not an attorney. I know you're listening to the attorneys. That's how you have to operate in life. Humans are not going to be experts on most things that they are aware of and engage in and do in life. So if you're just trying to understand something because you can't be an expert on most things that you do in life, then you look to the experts, have them argue with one another, and then you figure out for yourself who makes the most sense. And then you come to a conclusion, and hopefully that's good enough. That's how life works. And so that's what I'm doing here, and I think Attorney Deaton has the most compelling case on this topic. And so I do feel optimistic about that. Let me know what you think, but I'll wrap up here. I'm not a financial advisor. You should not buy or sell anything because of anything I say or write. That would be a very, very, very bad idea. Until next time, to the Moon Family Sedan.